All right, if you're gearing up for the Queensland bar exams, you know procedure isn't just a detail, it's the whole game. Today, we're diving deep into one of the most powerful and, frankly, most important rules you'll ever use, UCPR Rule 371. And look, getting this right isn't just about ticking a box on an exam, it's about knowing how to pull a case back from the brink. Let's get into it. So let's kick off with a scenario that you are absolutely going to face, probably sooner than you think. Your opponent messes up. They file the wrong form, they blow past a deadline, they just don't comply with an order. Is this it? Is this the golden ticket, the knockout blow that ends the whole thing right here, right now? Or is it just a little stumble? How you answer that can make or break your application. And the answer, the entire key, lies right here in this fundamental difference. Is the mistake an irregularity, a procedural stumble that the court has the power to fix? Or is it a nullity, a flaw so deep, so fatal, that it makes the whole step, maybe even the whole proceeding, void from the get-go? This distinction, irregularity versus nullity, that's the battleground where Rule 371 lives. Okay, let's drill down into the core principle of the Uniform Civil Procedure Rules, a philosophy that really favors getting to the real issues over winning on a technicality. Every single time you spot a procedural error, your analysis has to start right here. This is the rule you need to commit to memory. Rule 37.1, Subrule 1. This is your bedrock. Let's actually read it out, because every single word here matters. Rule 371, Subrule 1 states, a failure to comply with these rules is an irregularity and does not render a proceeding, a document, step taken, or order made in a proceeding a nullity. You hear that? The default position, the starting point in Queensland, is that mistakes are fixable. They are irregularities, not automatic game enders. And I love this analogy because it just perfectly captures the spirit of the rule. Rule 371 is the court's ER. It's there to stop a case from flatlining because of a technicality. And that all ties back to the big picture, the overriding purpose of the rules, you see in Rule 5, to get to a just and speedy resolution of the real issues in dispute. So, if a mistake is just an irregularity, what can a judge actually do about it? Well, that takes us to the court's toolkit, the very specific powers it's given under Rule 371, Subrule 2. Just look at this list. It shows you just how flexible the court can be under Rule 371, Subrule 2. A judge can bring out a sledgehammer and set aside the whole proceeding, or they can use a fine-tipped scalpel and just declare a single document to be perfectly fine. It's this powerful discretionary toolkit that lets the court fit the solution perfectly to the problem. Let's make this real with an example. In Amos v. Wiltshire, there was a tiny error in calculating the daily interest on an enforcement warrant. The other side jumped on it, arguing the whole warrant was a nullity. But the Court of Appeal, they said absolutely not. They made it clear that Rule 371 gives the court the power to simply fix the document. And just like that, they saved everybody the huge cost and delay of starting the whole application over. That is the rule doing its job perfectly. Okay, now this is absolutely crucial for your bar exam submissions. The court can fix an error, but it doesn't have to. It's all discretionary. So, how do you persuade a judge to use that discretion to help your client? Or, on the flip side, how do you argue they shouldn't help your opponent? The case you need to know here is Lutheran Church of Australia. It gives us this fantastic checklist. When a judge is weighing up a Rule 371 application, these are the things they're thinking about. Was it a simple slip-up, or was someone deliberately flouting the rules? Did the party asking for help sit on their hands, or did they act fast? And this is the big one. What's the prejudice to the other side? Your submissions, your advocacy has to tackle these points head-on. So far, Rule 371 seems like this amazing safety net, right? But it's not invincible, and for your exams, knowing when Rule 371 cannot save you is just as critical as knowing when it can. Let's talk about the danger zones. Remember that distinction we started with, irregularity versus nullity? Well, here's where it really bites. Rule 37.1 only works on irregularities. If a mistake is so fundamental that it goes to the court's basic power, its very jurisdiction to even hear the case, then it's a nullity. And a nullity is void. It's a ghost. Rule 37.1 has no power to bring it back to life. So what does a real nullity look like? Well, the cases give us some pretty clear signposts. In Bugler, a party hadn't met a condition required by statute before they were even allowed to sue. That's a nullity. In Gregg, an order was made after one party was denied their right to be heard, a massive breach of natural justice. That's a nullity. And in Bendigo Bank, an application was based on an affidavit that was just stuffed with inadmissible evidence. The court said the very foundation was rotten, and Rule 371 couldn't fix it. Okay, the first high-risk area you have to have burned into your brain is contempt. Anytime someone's liberty is on the line, the courts demand nothing less than absolute perfection on procedure. This quote from the Court of Appeal in Cam v. ASI says it all. The procedure is a matter strictus semi juris, of the strictest law. In that case, someone forgot to include the mandatory penal notice required by Rule 665 on a court order. The court made it crystal clear. This was not some minor irregularity that Rule 371 could just wave away. The lesson? If you're running a contempt application, you check the rules once, twice, 3 times. Get it perfect. All right, the second classic exam trap is how Rule 371 interacts with delay, and specifically with Rule 389. That's the one that deals with cases that have gone quiet for 2 or more years. And the key lesson from Your versus Robertson is this. Once a case is automatically put on ice under Rule 389 because 2 years have gone by, you can't just revive it by taking some irregular step, like sloppily serving a list of documents. That irregular step doesn't count. It's ineffectual. The proceeding is still stayed, and you still have to go to the court and get permission to move forward. You can't use Rule 371 as a backdoor to get around Rule 389. Okay, we have covered a huge amount of ground. So let's take a breath and boil all of this down into a simple, strategic framework you can take with you straight into an exam. This is your cheat sheet. Filed an appeal on the wrong form? That's a textbook irregularity. Rule 371 lets the court fix it. Simple. Taken a step after 2 years of silence? No good. Rule 389 and Rule 371 work together to say your case is stayed and your step is useless, just like in Ure v. Robertson. Missed that crucial penal notice on a contempt application? Rule 665 demands strict compliance, so Rule 371 probably isn't going to save you. And a small calculation mistake, like in Amos v. Wiltshire? That's the classic irregularity the court can and will fix every day of the week. And that's our deep dive into UCPR Rule 371. The biggest takeaway is that this rule forces you to be a strategist. It's never just about spotting a mistake. It's about diagnosing it. Is it a curable irregularity or a fatal nullity? And then understanding how to argue the court's discretion. So the final question to leave you with is this. The next time you find that flaw, will you know whether you should be arguing for the scalpel or for the sledgehammer?